Good afternoon. The clerk has reported that everyone has signed in who should be signing in, and we can therefore dispense with the call of the calendar, and we will begin argument with the first of the cases on the calendar, George against United Nations.
May it please the Court. I'm Beatrice Lindstrom with the Institute for Justice and Democracy in Haiti, and I represent the appellants. I'd like to reserve 2 minutes for rebuttal, please. Your Honors, appellants are Haitian and American victims of a devastating cholera epidemic caused by the UN through gross mismanagement of sewage.
Let me ask you this. Has anything been, I don't know whether the record reflects this, but can you just briefly let us know, has anything been done to remediate this situation? Any compensation been paid to these victims? How do things now stand?
There has not been any compensation paid to the victims. There is a plan that has been launched by the United Nations that was referred to in the brief by the government to eliminate cholera in Haiti through water and sanitation. That plan is drastically underfunded and has not yet really begun implementation, and the Office to Coordinate Water and Sanitation in Haiti, which I believe was also referred to in the government's brief, has now unfortunately been closed down. The appellants come to this court as a last resort because, unlike the appellants in Berzac, they have been denied access to any mode of settlement. Now the United Nations, an entity created by international human rights law to promote human rights, to respect treaty obligations, asks this court to selectively enforce the Convention on Privileges and Immunities, to grant it privileges while at the same time absolving it of its own duties under that same treaty. This is an unprecedented interpretation of the Convention. It violates the plain text of the treaty, of international law, and emerging consensus among foreign courts that the UN's conditional immunity does not authorize impunity. At the center of this appeal, Your Honors, is a narrow question of first impression that is not controlled by Berzac versus United Nations. In Berzac, the UN complied with its obligation under Section 29 to provide plaintiffs with a process to settle claims, and therefore it satisfied a condition precedent to its invocation of immunity pursuant to Article 2 in the Convention.
Assuming that it is a condition precedent to the immunity, who has the right to enforce the provisions of Section 29?
Well, Your Honor, I think that this is not a pure question of enforcement. Rather, it's a question of whether Section 2 comes into play in the first place.
Well, that happens if Section 29 has not been complied with.
Right, so where is
on your interpretation, right? So why would individual citizens of Haiti have the right to invoke Section 29 and get a domestic United States court to decide whether the United Nations has breached that obligation?
Your Honor,
and what would follow if they did?
So this is not a case where the plaintiffs have filed suit to seek enforcement of Section 29. This is a case that arises in tort. It's a case over which the district court would have jurisdiction, but for the U.S. government essentially asserting an affirmative defense of immunity. And so the court, in assessing the question—
The U.S. government isn't asserting it. They're here as amicus. The United Nations— we have to decide. I take it you agree that this is analogous to sovereign immunity and is therefore something that is treated as jurisdictional?
Right. It's a question of jurisdiction, and in assessing whether Section 29 applies to this case to bar the district court from asserting jurisdiction, the court would read the treaty as a whole and assess whether the conditions precedent to immunity under Section 2 has been met. And so in Berzac versus—
Wouldn't it normally be for the state parties to the treaty to invoke Section 29 and serve notice on the United Nations that it's not complying with its side of the treaty and therefore the treaty is abrogated or some other provision of the treaty is abrogated? Why isn't that something for the United States or Haiti or some other country to invoke?
Because this is fundamentally a question of the court's jurisdiction. And so the court has the power and regularly does assess its jurisdiction the same way that it would if this case raised other types of questions around immunity. There's nothing different about the fact that this immunity comes from treaty as opposed to statute, for example, because plaintiffs are not bringing suit. They're not seeking to enforce a cause of action under the treaty. The Convention on Privileges and Immunities is not something that at all has any weight in our lawsuit. The lawsuit is one that arises in tort, and the convention only comes up in the context of the government's brief where they put forth the argument that because of the convention, the court does not have jurisdiction.
So absent the convention, it's your view that you could bring a tort action in New York?
Yes, Your Honor. This is the correct forum for this claim. New York is the place where the United Nations is headquartered. It is where both defendants, Mr. Bond and Mr. Millay, reside. There are 2 U.S. plaintiffs in this case, and so they are bringing the suit in their home country against defendants who are also located here and who are based here.
And the substantive law would be Haitian law or New York law or something else?
I believe it would be New York law, but that is also a question that could be determined at a later point.
Yeah.
So Berzak versus United Nations, of course, a case that was decided by this court, is an example of how Section 29 works when Section 29 is complied with. The plaintiffs in that case, they filed claims. Those claims were considered. They were decided on the merits, and the plaintiffs were given remedies. And they also had access to an appeals process. And so in that situation, breach of Section 29 was not at issue before this court in deciding that case.
Well, wasn't the argument of the plaintiff in that case that the remedies provided were inadequate to really comply with Section 29?
One of the 7 arguments that the plaintiffs in that case made before the court was that the remedies were inadequate. But that is a very different question from the one that's before the court today. And if I may explain why.
Would you draw a bright line around cases where there is simply no remedy available?
We would, Your Honor.
So if the UN created an arbitration forum in which Mr. Bond, for example, got to decide his own case and decided that there was really no liability, that would be good enough?
Well, reasonable people may disagree about what constitutes adequate process in any given case, but the situation
I thought you were drawing a bright line. I thought I just asked you that, whether you were drawing a bright line around no remedy or whether you were suggesting that a court like this one would have the power to decide whether the remedies are adequate. Are you now suggesting that we would, and that the real explanation of Berzak is that in that case we correctly thought that there were adequate remedies, but if we had thought there were inadequate remedies, it would come out the other way?
No, Your Honor. We do draw a bright line between cases where there has been no process and cases where there are allegations that that process wasn't adequate. This is a case where on the face of what the United Nations has responded with to the plaintiffs makes it clear that the processes that were promised, the Convention on Privileges and Immunities and other legal documents coming from the United Nations have established a minimum floor of the process that must be given.
What is that minimum floor?
So in the convention,
if the UN said we don't think we did anything wrong and we've looked at it and there's nothing wrong, so goodbye.
Well, in this case, the United Nations has not said that. They have not made a merits determination. They simply said in one conclusory line that the claims are not receivable because they involve a review of political and policy matters. That is not an exception that is recognized under any of the laws that the UN relies on to make Section 29 decisions. And so on its face, it's a statement that's invalid and that does not present any legitimate reasons for rejecting the claims.
If this had been the United States Army and a claim were brought against the United States, there would be immunity for that, would there not?
That would be decided under a different framework.
Well, maybe so. I'm just asking you, do you know the answer? Would it not be the case that if these were American rather than Nepali soldiers serving under the American flag rather than under the United Nations flag, there would be immunity. I think that's right, but I'm asking you if you know the answer.
I believe that that would be decided under the Foreign Tort Claims Act, which is restrictive immunity that makes distinctions between immunities that go to the core functions of the United States government and other types of tort acts.
But doesn't this go to the core functions of the United Nations? This isn't, I mean, the cases that you cite from European courts are things like routine employment disputes and things of that sort, where, in fact, some of the cases explicitly talk about the fact that these are not core functions. And isn't the most analogous case the Srebrenica case?
That case has very different facts from this case, Your Honor, in that...
Isn't that also a case, isn't that the only case of any of the ones that at least I've seen in the briefs of the parties or amici that deals with immunity or not for a peacekeeping force?
There is also the case of Stravino versus United Nations that arose in Cyprus. But I think that the situation can be very well distinguished here in that when the United Nations leaked its waste into Haiti's Central River, there was nothing about management of waste systems that goes to the heart of the UN's mandate. The UN's mandate in Haiti is to promote the rule of law. Management of waste is an ancillary activity to that. It is not anything that goes to the public functions of the United Nations. Even private actors regularly, on a day-to-day basis, have to be responsible for proper waste management. So there's nothing about that that's unique to the United Nations or that goes to the heart of its peacekeeping functions. In Srebrenica, the case was about whether the UN had properly used its troops to provide protection for vulnerable populations. If that was the case here, then it probably would not be a private law claim, and so it would not fall within Section 29.
Would you concede that there's nothing in the treaty, in the text of the treaty itself, that makes Section 29 an exception to Section 2?
Well, Your Honor, I think when you read the treaty as a whole, as the rules of treaty interpretation require, it is clear that Section 29 is linked to Section 2. They cover the same content. They govern the rights and obligations that attach when a claim is filed that alleges that the United Nations is responsible for injury. And Section 29 refers back to Section 2 in discussing, making it clear that it is for the types of claims over which the UN has immunity that it also incurs this obligation. Now, conditions precedents do not have to be established clearly in the text. It's a question of the party's intent. And so to assess that intent, it's proper for the court to look at the drafting history. And as we spelled out in detail in our briefs, the drafting history throughout makes it clear that immunity was never intended to amount to impunity. It was always counterbalanced with the obligation to provide a settlement.
Well, it may be counterbalanced, but that's a little different than a condition precedent, right? Is there any indication, any explicit indication in the drafting history that says anyone thought that the immunity would dissipate if the remedies required by Section 29 did not materialize?
The study of privileges and immunities, which laid the groundwork for the convention, has language that I think is particularly instructive. The drafting committee there instructed the UN to provide alternative dispute resolution if, and it uses the word if, the UN does not want to appear in court. And so they understood that it was a necessary precondition to immunity, and so they wrote in a non-discretionary obligation in every draft of the treaty that followed. And to the extent that there is ambiguity in the precise nature of the relationship between Section 29 and Section 2, this court should resolve that ambiguity in a way that is consistent with background principles of international law, of the UN Charter, and of human rights law, which all make it very clear that the right to a remedy is an established right and which has been explicitly worked into the convention in Section 29 with the purpose of ensuring that individuals are not left without access to any kind of process.
Thank you, Ms. Lindstrom. I've given you some extra time, of course, but you have reserved 2 minutes.
Thank you, Your Honor.
May it please the Court. My name is Ellen Blaine. I'm an assistant U.S. attorney in the Southern District of New York, and I represent the United States, which, as Judge Lynch just mentioned, is not a party to this action. The U.S. is appearing here today because it is a party to the treaties governing the affairs of the United Nations. To Judge Parker's point, I'd like to first acknowledge that the United States understands that this case concerns a humanitarian tragedy, and the U.S. is sympathetic to the victims of the cholera epidemic in Haiti. And to that point, the United Nations itself has spent more than $140 million since the outbreak in trying to eradicate cholera. The United States itself has spent almost $95 million trying to eradicate cholera in Haiti. There are many multinational organizations there on the ground working to eradicate cholera in Haiti. And so while these plaintiffs in this court may not have recourse to sue the United Nations, is not the fact that the international community has turned a blind eye to the cholera epidemic. As the district court correctly concluded, Section 2...
Tort law does something different, right? I mean, if somebody is injured through the negligence of a commercial enterprise, we don't say, oh, look how well the company has done about seeing to it that this doesn't happen again. We look to giving compensation to the person who was injured by negligence, and that's what they're asking for, right?
Yes, Your Honor.
And nothing has happened on that front. That's
correct, Your Honor. And that's because the General Convention means what it says. And Section 2 provides, as this court ruled in Brizick, that the UN is absolutely immune, subject only to one thing, and that is express waiver.
Does Section 29 mean what it says?
Section 29 does, but Section...
So is the United States doing anything in its role as party to the treaty to insist that the United Nations create these mechanisms? Again, it's not a question of insisting that they get compensation. I have no idea whether there really was negligence or whether anyone deserves compensation. It's a question of whether there is some adjudicatory mechanism created by the United Nations itself to assess the claim.
So the United States could, well, under Section 30 of the Convention, request that the ICJ, International Court of Justice, issue an advisory opinion. The United States has not done that here. The government of Haiti has not done that here, nor has any other member of the treaties governing this.
So the sympathy that you mentioned that the United States has for these victims does not extend that far.
Well, Your Honor,
nor does it extend so I wasn't even thinking about, in effect, suing the United Nations in the International Court of Justice. What about just bringing to bear diplomatic pressure of some kind within the United Nations structure, where we are, I take it, an important player, to ask the United Nations to do something?
Your Honor, that's a separate question from what the treaties provide here in terms of the plaintiffs.
I understand, but you're the one who said the treaty means what it says. I respect that argument. But if you're here to come to this court to help us to make sure that the treaty is interpreted in accordance with its language with respect to Section 2, I'm just wondering whether you're anywhere else making the same argument with respect to Section 29.
Your Honor, the government does believe that Section 29 may well be enforceable. And there are two things that flow from that. One is, as Your Honor already pointed out, who gets to enforce that? Who gets to argue that the UN has breached that? And that is only the signatories to the convention. Second answer is, the United States right now has not asked for an advisory opinion from the ICJ. That does not mean, however, that that member states are not exercising their rights in the diplomatic realm or elsewhere to address the actual problem separate from the tort claim.
What would an enforcement action under Section 29 look like?
If the question, Your Honor, is how would a member state argue...
First of all, it's your position that it's only available to a member state.
That's correct, Your Honor.
And so how would it get, for example, initiated?
Under Section 30 of the General Convention, a member, via an organ of the UN, would request the ICJ to issue an advisory opinion. And the ICJ was formed at the same time as the UN Charter.
And the advisory opinion would say, let's say if your adversaries or your adversaries one would say what?
Well, I'm not sure that there would necessarily be any adversary in the ICJ, but assuming for the sake of argument that one member state argues that the UN's interpretation is incorrect, and the UN or some other member of the UN argues that the interpretation is in fact correct, in that the UN does not need to provide an alternative method of dispute resolution in order for Section 2 immunity to attach, the ICJ would evaluate that argument and issue an opinion. And that's what the ICJ is explicitly created for. The parties to the treaty in 1945 and 1946 evaluated this question and evaluated how disputes can be resolved among sovereign nations. And they specifically granted that right to the International Court of Justice in 1946. So any dispute about whether or not the UN's interpretation of Section 29 is incorrect, any dispute about whether or not the UN has breached Section 29, and any dispute about whether or not that breach in any way affects Section 2's immunity belongs to the member states, and it belongs in the forum of the ICJ.
The ICJ can't give any relief to these Haitian victims, is that right?
Well, Your Honor, these individuals would not be parties to the ICJ.
That's my point.
So playing this out, if the ICJ were to, down the line, issue an opinion that first, that the UN must establish this Standing Claims Commission or anything else under Section 29, then presumably the government of Haiti and every other portion of the UN affected by the ruling would then establish a Standing Claims Commission.
Could you tell me if I'm right about this? Is it the case that the United Nations has created some standing alternative dispute resolution procedure, and that the issue in this case is whether the claims made by the plaintiffs in this case are disputes of a private law character?
Yes, Your Honor. There are currently two ways for disputes concerning the UN to be evaluated and resolved. One is the United Nations has an internal dispute resolution mechanism for its own employees. It's not an issue here. The second way is in every mission that I'm aware of, the United Nations has created a, quote, board of inquiry. And the board of inquiry resolves these tort claims at a local level within the mission. And that's reflected in the record at A265, 266, and 277. So the UN has always acknowledged that it needs to provide tort compensation in effect, and does so in this way in the missions themselves, but has never, sorry, Your Honor.
No, go on. You're going to finish. I'm sorry.
And has never, however, established a, quote, Standing Claims Commission under the Status of Forces Agreement, because as the Secretary General has said, specifically Secretary General Annan in these places in the record, the Secretary General has always concluded that such a thing was not necessary because of these boards of inquiry.
In terms of the board of inquiry process, does that mean that if I were visiting Haiti and got run over by a jeep operated by someone wearing a blue helmet of the United Nations, I would have some ability to seek compensation through this board of inquiry?
Presumably, Your Honor, but as to why that potentially was not available to the plaintiffs, I'm not here as the United Nations lawyer, so I
understand. I'm just trying to understand, and what is the scope of the board of inquiry, and what kind of claims? Because to the extent that the issue is not, we're just not going to set anything up, but is instead we have set something up, but this particular claim doesn't fall under private law character. I'm just trying to get a sense of the scope of that argument. Does that mean, for example, that anything done by troops in the mission is not really a private law character, as opposed to somebody, I don't know what, has a contract to provide services to the mission and they claim they weren't paid?
Your Honor, I can answer that as a practical matter. Torts on a smaller scale have been compensated generally by the United Nations. In addition, mass torts, I will call it, lump sum payments to specific countries have been made by the United Nations. But as to what the United Nations legal analysis was as to these plaintiffs' claims, I
You're
cannot.
not able to speak because that's not your, is that what you're telling me?
That's correct.
That's not your, you're not privy to it?
Correct, Your Honor. And of course, the government's position is even if the UN's reading and conclusion were incorrect, that still does not eviscerate the immunity in Section 2.
Ms. Blaine, up to now, my colleagues have been going for the jugular, as it were, dealing with the UN Charter and the Convention on the Privileges and Immunities of the United Nations. Maybe I can go for the capillaries. What happens if we decide in favor of the appellants? I'm just trying to understand what the posture would be of this case. Is there any recourse for the United Nations at this stage in, for example, taking an adverse decision in this case to the Supreme Court? They're not here as a party, right?
That's correct, Your Honor.
They never entered an appearance.
That's right, Your Honor.
So what would be the procedural posture of this case if your adversaries were to prevail?
Well, Your Honor, obviously, first, the government's response is we do not believe our adversaries should.
Oh, of course.
Assuming that.
But you're an amicus. You're not a party.
Yes. Assuming that, I'm not sure procedurally exactly how the United States, as an amicus, can seek a petition for, seek cert from the Supreme Court. I'm not sure procedurally how that would work, but if the court would like, I'm happy to provide additional briefing on that.
Or whether it would work, I guess, is the first question. Do you have any standing to do that?
That's a question I've honestly never thought of, but we can certainly submit a brief if that would be of use to the court.
Thank you very much.
Well, in the other, you adverted to specific and individual specific torts and mass torts. Can you just tell us a little bit more about those procedurally? How are those tort judgments obtained?
Well, there's never been a tort judgment obtained, so a court has never evaluated the UN's liability under any common law or treaty or otherwise for a tort. But the UN does set up these boards of inquiry, and the individuals on the ground do an investigation, as far as I understand, and evaluate whether or not the UN has, hurt somebody with a Jeep, to use Judge Lynch's example, and therefore is entitled to some sort of compensation. That's sort of one set of claims. And then another sort of set of claims, and I think this has happened twice, the UN has given a lump sum payment to a country for, I think it was $13 million in one case, a substantial amount for a larger problem than just that doesn't just affect one individual within that country.
And how was the payment effectuated? I mean, who was the paying entity, and who was the claimant? You're just sort of.
Your Honor, I think it was just a diplomatic settlement, so there wasn't actually a tribunal that overlooked this or decided this.
Presumably the Haitian ambassador pressuring the UN.
Well, this was never given to Haiti.
I mean, not to Haiti, but the country's ambassador.
Yes, and I don't have a window into that particular procedure, but I know that the outcome of the procedure was diplomatic, and the outcome was some sort of negotiated payment between the parties. And by the parties, I'm using that term loosely.
I take it that's publicly reported somewhere.
Yes, and Your Honor, it's actually in the record as well, specifically at those pages I've mentioned, because in A266 is an evaluation that the Secretary General provided to the Security Council about how the UN goes about resolving third-party claims.
But in any event, your bottom line, your basic position is that there's absolute immunity here. And it doesn't, if the UN did nothing or cared to do nothing, none of the things that we've been discussing in the large, if it did nothing, and it indeed said that it would do nothing, it has absolute immunity.
Yes, Your Honor, and that's based on several things. Just briefly, the text of the convention, the drafting history of the convention, this court's ruling in Brizik, and just unfortunately, the plaintiff's claims here cannot be brought here, and they cannot be brought by these plaintiffs.
Anywhere?
It would be up to the members of the signatory countries of the General Convention. So it would only be, if it's a dispute between the UN and Haiti, it would go to the ICJ under Section 30 of the Convention. If it's a dispute between MINUSTA and the UN, it goes to a tribunal of arbitrators, and that's under the Status of Forces Agreement at Section 58.
Would the United States government concede that the result that you rehearse is a very, very bad result?
The result that the United States urges is a bad result?
Would the United States government concede that if you're right and these people are completely remedialist, that is a very bad result?
Well, I think the United States certainly recognizes that this is an unfortunate and tragic humanitarian catastrophe. But again, at the end of the day, the United States is here to urge one interpretation of the treaty that the member states have always held. So yes, we would say that it would be unfortunate for these particular plaintiffs. On the other hand, it is not necessarily a quote-unquote bad result, as Your Honor is suggesting, because the member states of the UN have conferred absolute immunity on the UN for a very important reason.
Sovereign immunity, like absolute immunity for judges, like absolute immunity for prosecutors, like qualified immunity for police officers. There are lots of situations where people are left without a remedy even though they were wronged.
That's right, and those immunities are vital, and particularly for the United Nations, to carry on its peacekeeping mission around the world.
Thank you.
Thank you, Your Honors.
Ms. Lindstrom, you've reserved 2 minutes.
May I just ask, Ms. Lindstrom, you started by saying that what the UN is asking is unprecedented. Is there any precedent for a domestic court of any country awarding tort damages against the United Nations?
Your Honor, there are in other countries. In the United States, there's...
No, in other countries as well, for awarding tort damages against the United Nations, not UNESCO under the Paris Court's interpretation of a treaty between UNESCO specifically and France, and more, I might make it even narrower, for tort damages arising out of a peacekeeping mission. You mentioned the Cyprus case. That went against the plaintiffs. The Srebrenica case essentially goes against the plaintiffs. Is there any case that has gone in favor of the plaintiffs that is remotely analogous to this one?
Well,
that doesn't say, that wouldn't, is not saying anything about the substance of your argument. It's just about what is precedented and what is unprecedented.
Sure. Cases against the United Nations headquarters itself arise almost exclusively in the United States because that is where the United Nations headquarters are found. And so that is why you see cases against UNESCO arising in France. You see cases against the Food and Agricultural Organization arising in Italy. And so it's not that courts have sat in judgment of this question, have decided on the merits that, or as a matter of a jurisdictional inquiry, that it could not issue it could not hold the UN liable in tort. It's simply that those questions
I'm
have
not suggesting there's necessarily a square precedent against you. I'm just trying to figure out if there is any case in which any court of any country has awarded tort damages against the United Nations, A, at all, and B, specifically out of a peacekeeping mission's activities.
This is a sui generis case, Your Honor, and I think that that's partly going back to Ms. Blaine's point that the UN settles claims every day. It settles claims for tort disputes, for contract disputes, including in peacekeeping operations. If the UN contracts to have somebody supply paper to its mission and it breaches that contract, it would settle that claim. And the way that it does that is by engaging in amicable attempts to settle with claimants, with individual claimants. It is not dependent on a government raising those claims. And importantly, in the Status of Forces Agreement, the Standing Claims Commission is a commission of last resort. In A266, the document that was referenced by Ms. Blaine earlier, the Secretary General also assessed that provision and said, in fact, that there was a reason to retain it because otherwise the UN could be seen as acting as a judge in its own case. The Secretary General also noted that one of the reasons why the Standing Claims Commissions have not been invoked previously is because the victims have not asked for it. And Your Honors, in this case, victims have asked extensively for a Standing Claims Commission, and that has been rejected.
Thank you, Ms. Lindstrom, very much.
Thank you.
We reserve decision, and then we'll hear the second case on the calendar. USA versus Cornegay.